What should I do if my marriage-based green card is denied? Hi, I'm Jim Hacking, immigration lawyer practicing law throughout the United States at our offices in St. Louis, San Diego, and Washington, D.C. In this video, we're going to talk about that sad situation that happens when USCIS sends you a denial notice on your I-130 or your I-485. This is for people who have married a U.S. citizen or a lawful permanent resident and have applied for adjustment of status based on that marriage, based on marriage to that U.S. citizen or green card holder, and for whatever reason, they get a denial. Now, this is not a good thing. It is not good to get a denial, and it's obviously very upsetting. You've waited a really long time, you spent a lot of money, you spent a lot of effort, and for whatever reason, USCIS has decided to deny your case. And really, at that stage, you have two options, maybe a third, and let's go through each of them. Your first option, which is actually suggested to you in the denial notice, is to file an I-290B, which is a motion to reopen or reconsider. You could certainly do that. When you do that, you file that form, the I-290B, you pay a filing fee, and off your case goes for reconsideration. Now, we are not a big fan of the I-290B at our office. You certainly can do it, and maybe in certain circumstances, you might do it if there's a clear legal issue as to a mistake that was made. Now, if they're saying you just didn't submit enough marital evidence, that there wasn't enough marriage evidence to meet your burden of proof, that you have not satisfied them that your marriage is for legitimate love reasons and not to obtain an immigration benefit, something like that, where it's a judgment call, a 290B is probably a loser. And what your second option is, and the one that we're going to recommend probably 95 times out of 100, is for you to simply file a new case. There are lots of benefits to filing a new case. Number one, you have a chance to rebuild your case, to start over from scratch, to maybe get help from an immigration lawyer who knows what they're doing, to file a much stronger case. But more importantly, you're going to have the chance to apply for a work card and a travel document again. Now, when you file the 290B, you don't have any real status. If you received a work card or advanced parole and then your green card case was denied, then your work card and your travel document are no longer valid. Once the 485 is denied, then the underlying work card and travel document are invalidated. They are no longer legitimate and you should stop using them. So when you file an I-290B, you don't get a new work card. You don't get to keep using your travel document. There's no basis for filing for those documents as part of the 290B. So the greatest reason why you should file a new case and not a 290B is because that will give you the opportunity to get back in status, to get that work card, to keep working if you have a job that checks these things, or to travel outside the United States, which frankly, if your green card case was denied, you probably shouldn't do, but it's still nice to have advanced parole in case you need it. So we are a strong advocate for refiling the I-130 and the 45. Obviously, you're going to have to pay the filing fees again. Obviously, you're going to have to wait again. And obviously, you have a black mark on your record because of the earlier denial. So those are all complicating factors. Now, there's one little thing that we do in a very small number of cases. If we thought that this was a case in which they made a clear mistake, it wasn't USCIS exercising their discretion, but instead it was something that they did that was really dumb. For instance, if you received a notice of intent to deny or a request for evidence and they gave you 30 days to answer, and you have proof that you responded on the 25th day, then that might be a situation where I might sue them. And I might sue them for several reasons. One is you can get these cases cleaned up very quickly when USCIS has made a clear error. Because when you sue them and argue that they've misapplied the law to the facts of your case, a U.S. attorney is assigned to the lawsuit. And the U.S. Citizenship and Immigration Services have their own general counsel. And they all talk about this decision that was made. And if there was a clear error, you are going to get most likely a reversal without much litigation. You're probably not going to fight that out for long. They don't want to go into federal court and argue that their adjudicators made the correct call when it's obvious to everyone that they did not. So we have done this more and more, and we really like doing it because you receive that denial notice. You can't really get a hold of anyone to explain to them their dumb mistake. You can't really get a hold of the field office director. And sometimes your only shot is getting them to admit they made a mistake after suing them. And what you do is you sue them and say their decision was contrary to the law, it was arbitrary and capricious, and judge, you should reverse it. They don't want a judge to decide that, to order that or to rule that they have to reverse themselves. So instead, they take a look at it with fresh eyes, with a higher level of scrutiny from attorneys who understand the INA and the immigration laws and regulations. And if it's something where they just flat out got it wrong, a lawsuit might be the third option for you in a very limited number of cases. Hope that makes sense. If you have questions about what to do if your marriage-based green card gets denied and you want to get started over, or you want to sue them, or you even want to file a 290B, that's something we could certainly discuss. If you're serious about hiring us, call us at 314-961-8200. info@hackingimmigrationlaw.com is our email address. You can reach us there, and you can inquire as to working with us and what that's like. We have lots of free resources for people who don't want to hire us. So if you don't want to hire us, please don't call the office. If you just want to get an information or have a consultation, we don't really do that. You can call if you're thinking about hiring us. If you're serious about moving ahead with us as your lawyers, that's just fine. If not, we offer a immigration answer show, which is a show that I do 3 or 4 times a week. It's me going live, answering as many immigration related questions as I can in an hour, trying to help the community to give back and to teach people a little bit of something about the U.S. immigration laws. We also have a Facebook group. It's called Immigrant Home. You can join us there, and you'll get alerted whenever I go live on the show. You can also talk to other immigrants going through the immigration process. You can follow us on TikTok @ImmigrationHacking. And finally, like I said, we have that immigration answer show. We'd love to have you join us there. If you want to get on our text line so that you find out when we're going to go live next and get in that waiting room so you can ask me a question, text the word SHOW, SHOW, to 314-470-3300. Thanks a lot, and we'll see you next time.